Lawyer Elisha Ongoya joins me now to discuss what is going on at the ICC at the moment, and just for a clearer understanding, because many of these terms are thrown around quite a bit.
Yes.
Thanks for joining us on KTN Prime tonight.
Thank you so much.
So let's start off with where we are now. The motion of no case to answer.
Essentially, by a motion of no case to answer, we just mean an application that if you look at the case as set out by the prosecutor, the evidence as accused, it does not disclose such a case as should waste Honorable Ruto's time and Mr. Sang's time adducing any evidence in defense. That's essentially what Mr. Ruto and Joshua Arap Sang seek to convince the trial chamber on. So that's the stage at which we are. This is a stage after the close of the prosecution case. By close of the prosecution case, we mean the prosecutor has determined that he has adduced all the evidence that he could possibly marshal in the context of this case, and he has informed the court that he has now closed his case. So the other side is now asking, looking at the entire evidence that you have adduced, have you made out the case that you set out to make out? If you have not, we have no business adducing evidence to respond to nothing, as it were.
All right. Let's talk about Rule 68 for a moment. That controversial one was a subject of discussion at the ASP. A number of, the politicians that accompanied Kenya's delegation to the ASP claimed victory. Let's talk about the state of Rule 68 at the moment.
First of all, let our viewers understand, what does Rule 68 provide? Rule 68 allows the prosecutor to be able to use pre-recorded statements of witnesses who have since recanted their evidence. This has become quite a feature at the ICC, particularly in the context of the Kenyan case, but even before the Kenyan case, the Charles Taylor case also had a similar experience where quite a bit of witnesses who had recorded their evidence recanted their witnesses. So the rule remains intact. The rule has never been altered. The rule has never been changed. It has not been amended. It remains as it were by the time the determination was made that it's usable in the Kenyan case. The question that Kenya has raised over time has been that in the context of the framing of this rule, there was some assurance that this rule will not apply to the Kenya case. As to whether that assurance indeed was there or was not there is a question that is outside our domain, because that was within the boardrooms of the discussion. But the judges who were presented with this question made a determination that that rule will apply to the Kenyan case. Of course, the Honorable William Ruto and Joshua Arap Sang have filed an appeal to the appeals chamber against that determination. But even as that appeal was pending, we'll remember that Kenya pushed the just concluded session of the ASP to include on its agenda a discussion on the status of Rule 68. And I mean, and you need to understand that ICC is an international justice system that fuses many legal traditions from different backgrounds. You have many states from different legal traditions meeting at the round table to put their thoughts together. If you look at many European nations, respect for independence of institutions is at its peak. And therefore, many European nations, even in the context of that discussion, were very uncomfortable. That if this matter is pending determination at a court, entertaining and discussing it at this level would appear to be interfering with the independence of the court.
And that an appeal had already been lodged by the time we were going to the Assembly.
So that the logical thing would be allow the court to make a determination. But anyway, Kenya at least managed to push through one aspect, that the proceedings of that meeting do take note of the fact that the rule was not intended to apply retrospectively. So there was a note to that effect in the proceedings of the minutes.
But no change.
There's no change in the rule.
To the fundamentals of Rule 68. So as of now, it's still in play. Where we wait for the decision of the appeals
But
chamber.
in the meantime, it is still applicable, because the existing decision of the court is that it applies, and there is no decision of the appeals chamber staying that original decision of the court or overturning it. So the prevailing decision of the court is the rule applies, which is the trial chamber decision.
All right. So from here, we wait to see the decision of the judges, of the appeals chamber, and also of the judges in respect to this motion that has been filed by the deputy president, seeking a no case to answer. But let's talk a little bit generally, just for a few minutes, about the ICC. Like we've been saying, quite a bit of criticism has been leveled against this court. We're even asking our viewers today whether it can be that big stick to wield, against errant politicians. Is the ICC a perfect institution?
If it were a perfect institution, then it would be a God-created institution. Any creation of mankind has imperfections, and it will continue to have imperfections. In fact, to my mind, criticisms against the ICC are not necessarily a bad thing, because this is an institution like any other that must remain within the eye of the storm, so to speak, so that it's conscious of the need for it to meet the high benchmark, the high bar of expectations of consumers of its processes. So that is at the first move. At the second move, the ICC is an important institution. It's an important issue because the world has witnessed many atrocities, many things that shock our collective conscience of mankind. We saw this way back between 1939 and 1945 during the Holocaust. We saw this in Rwanda. We saw this in Sierra Leone. We saw this in Liberia. We saw this in Yugoslavia. We saw this in Kenya. So that there are many things that we saw this in Darfur. There are many things that have happened in the world where once we put aside the politics of the situation, we can at least agree that for us to have done this as human beings, we fell against our own human expectations, expectations of our own conscience as human beings. So once that happens, there must be an institutional framework within the family of human beings that can be able to deal with these situations as and when they arise. And therefore, the ICC is one of those institutions that have been set up to deal with this kind of situations.
In under a minute, what would we need to fix with the ICC to make sure that it's not a perfect institution, but, you know, a better institution?
A number of things. One, the Office of the Prosecutor itself has agreed that the mode of investigation they adopted before was incremental investigation. So that Ocampo, for example, got just a threshold of a case to prove to the pretrial chamber judges that I need to go in Kenya and investigate. Then after that, he got just a threshold of a case to show that this case ought to go for trial, to build the case incrementally. I think even Fatou Bensouda herself has said, moving forward, she will ensure that by the time she moves the court at any level, she has a ready for trial case. The second thing is that the ICC witnesses have been badly interfered with, meaning that the witness protection strategy of that court is something that is in need of thorough revamping. One may ask, with all the resources the court has, how has it been possible for people to crack down at its witness the way it has been? So looking from that experience, I think another thing that is in urgent need of reform is the question of witness protection. Thirdly, for me, is the question of the speed of the trials. Talking about only 2 convictions in 13 years with the rate of destruction we see in our own society, it's something quite discouraging. And I think the pace of the trial is something that may need to be enhanced.
Justice delayed, justice denied. Thank you very much. Elisha Ongoya, a lawyer, giving us perspective on where the case is at for Deputy President William Ruto and radio journalist Joshua Arap Sang, as well as way forward for the ICC in terms of making it a better institution. We want to continue our focus on what is going on at the ICC and